It seems to me the normal way anybody reads a text is, what does it mean?
Justice Scalia, from his brief exposure to the D.C. Circuit and his awareness of what was going on there, both before and after he became a judge, did not like judges, running off and making policy judgments on their own. He saw Chevron as a way of kind of holding that temptation in check, which I think explains why his great enthusiasm for the Chevron doctrine.
It's known as the Chevron Deference. It allows federal agencies to interpret ambiguous statutes, and federal courts must defer to their rulings. Some have recently pushed back at the ruling, indicating that the Trump administration, as well as Justice Gorsuch and the late Antonin Scalia, say no more.
Justice Scalia was one of the strongest advocates of Chevron deference, and that may seem kind of counterintuitive today. Justice Scalia's jurisprudence was one of rules and judicial administrability, and Chevron deference was a bright line rule. That could be easily applied by the lower courts and by regulated entities, so it brought certainty and reliability to the process.
Justice Scalia has got an extremely interesting relationship to Chevron. So he was sitting on the D.C. Circuit at the time Chevron was decided, and the D.C. Circuit is and was the circuit that hears the most of these cases involving challenges to agency decisions and interpretations of statutes. He only wrote in 3 cases where Chevron was mentioned. There's no sign that he was really a Chevron groupie when he was on the D.C. Circuit. But shortly after he got onto the Supreme Court, he very quickly established himself as the justice who was very passionately committed to the Chevron approach to reviewing agency questions of law. He wrote a law review article in 1990 in which he extolled the Chevron doctrine, largely on the grounds that it was more rule-like than the multifactorial approach that preceded Chevron. He didn't suggest necessarily it would result in more deference to agencies, but he thought it was one that was, because of the 2-step process, more of a rule-like structure as opposed to an amorphous multifactorial test. He hated multifactorial tests. But Justice Scalia, there's one opinion toward the very end where he seems to express maybe some tentative doubts about whether this all was right or not, but unfortunately he died before he could clarify his views.
I actually think that although Justice Scalia was very much, for much of his judicial career, one of the foremost proponents of Chevron deference, I think by the end of his career, that was very much eroding. And I think he was potentially on the verge of really reconsidering that in a pretty fundamental way. And I want to make that point really through the lens of a closely related form of deference, so-called Auer or Seminole Rock deference, where he did fundamentally evolve in his views and change his mind.
Judging by Justice Scalia's opinions and his public statements, I think it's fair to say that his views of Chevron did change over the course of his tenure. I think at least partly as a result of the fact that his colleagues did not always follow his vision of Chevron. And because it wasn't evolving in the way that he thought it should, and I think too because he recognized that it had become a tool on occasion for judicial abdication of the court's appropriate role, he became less enamored of Chevron, not necessarily as a doctrine per se, but as a doctrine as applied.
I think that Justice Scalia probably grew a little tired of Chevron at the end because his approach to Chevron was that at step 1, the answer was almost always that the statute was unambiguous. He would apply all the tools of statutory interpretation, including terms of art, in order to eliminate ambiguities where a lot of other justices and other judges wouldn't. And so for him, deference didn't usually apply because statutes were clear.
So I do think as his views evolved on Auer, I think he also planted the seeds for even a greater reconsideration of Chevron.
The court's application of the Chevron standard has changed substantially over time. There's great disagreement among the justices about exactly what Chevron requires. We have lots of arguments among the justices about the scope of Chevron's domain. We have lots of arguments among the justices about exactly how robust the inquiry ought to be at Chevron Step 1, just as we have disagreements among the justices about the proper role of legislative history in statutory interpretation, or how much significance ought to be given to statutory purpose in evaluating statutory interpretation. As the disagreements among the justices have unfolded over time, of course, Chevron jurisprudence in the Supreme Court has changed along with it.
Justice Thomas more recently has become skeptical about the Chevron doctrine, and Justice Gorsuch seems skeptical about the Chevron doctrine. So stay tuned. We'll see what happens going forward.